Hello. Uh, okay, we can start now. Students will join, and they are joining actually.
Okay. Okay. So shall we start now?
Yes.
So good afternoon, everyone. My name is Subham Singh, and I am working as examiner of patents and designs in NIPAM, Kolkata. And I'm here to present take a session on intellectual property rights, awareness session on intellectual property rights. That is under National Intellectual Property Awareness Mission, NIPAM. So we have two basic questions here. So first of all, what is intellectual property right? And the second question arises here: why we need such session? Like this session on awareness session on intellectual property rights. So we will address first question first. See, that is what is intellectual property right? So we all know properties can be of two types. First is tangible properties and second is intangible property. Tangible property is normal, which we see, that is physical property that can be touched. So tangible properties, the properties that are physical in nature and that can be touched and feel. For example, gold, car, house, furniture, equipments. So basically, the general property which we see in our daily life, they are tangible properties. And then comes the intangible properties. These are the properties which are creation of mind or creation of human intellect. For example, an invention, literary and artistic works like a novel, a design, a symbol, and many more. These are intangible properties. So our second question was like, why we need such session to aware on the intellectual property right. So basically in India, we have lots of intellectual properties. We have human intellect, and we apply the human intellect to create some inventions, some literary works. But in lack of knowledge and information, we do not protect these intellectual properties. So we are conducting these type of sessions to aware people for protecting their intellectual properties. So intellectual property rights may be of many types, like patents. If you have invented something, then it will come under patents. Then we will see these intellectual property rights one by one. The second one is designs. Then we will see trademarks, geographical indications like Darjeeling tea. Then there will be copyrights. We will receive copyrights for literary works and artistic works, and then there will be semiconductor integrated circuits layout designs. We will see these intellectual property rights one by one. For example, let's look at this laptop. This laptop have a LED display. This LED display must have obtained. This is a kind of invention, and it must have an patent. And then secondly, there is a body of laptop. The body of laptop have a specific design. So this will come under design, intellectual property right. And here you can see there is a logo of Apple sign. This will come under trademarks. And the similar way, we will receive a user manual with this laptop that will come under copyright. And in similar way, there is a layout of integrated circuits of laptop, and then that will come under SICL design. So this is just an example to show you, like in a single product, there may have more than one intellectual properties. Like here we can see there is patent, there is patent, there is an involvement of patent also, design also, trademark, copyright, SICL design also. So you can understand intellectual property right by this diagram. Every human has brain, he have intellect, human have resource, he have resources also, and he will apply some labor on it with brain and resources, and then that will result into a property, and that property will be known as intellectual property. And when we will protect that intellectual property, that will be known as intellectual property rights. So basically, intellectual property right is a certificate to protect, to prevent our intellectual property. What is the importance and significance of intellectual property right? We have seen intellectual property right makes us to protect our intellectual property. Like if we have made some inventions, then we can protect it through intellectual property right. In similar manner, we can exclude others from using our intellectual property. If we have intellectual property right, we can say to others like this is our exclusive intellectual property right. You cannot use it. If you want to use it, give me some money or anything else, then I will allow you to use my intellectual property right. In a similar manner, by doing this, we can utilize our intellectual property, we can commercialize it, and we can earn money from this use of intellectual property right. How can one utilize and commercialize his intellectual property right? First of all, if somebody invented something, then he can use for himself also. That is own use, and he can license or assign his intellectual property right to others. In the similar manner, he can give franchises and merchandise his intellectual property rights to earn money from his intellectual properties. Here, you can think when I am saying intellectual property, you can relate it from an invention only. What's the difference of intellectual property right for a common person with a businessman? For a common person, if he has some intellectual property right, it will be a matter of pride for him. Like some student have some invention in his name, it will be matter of pride for him, and it will be also useful for his academic purposes also. On the other hand, for businessman, if he have intellectual property right in his name, then he can commercialize his intellectual property right. It will increase his brand value, and he can earn and invest with his intellectual property right. So we have we received some basic idea of intellectual property right. Now we will see one by one different kinds of intellectual property rights. First intellectual property is patents. So let us see what is patents. So basically, patent is a grant of sovereign or state to a person giving exclusive right to stop others from making, using, exercising, building, and importing an invention for a limited period in exchange for disclosing it in a patent specification such that anyone having average skill in the art can reproduce the invention. That means if somebody has invented something, so he will go to patent office and disclose it to patent office, and patent in return of that, patent office give him exclusive right to stop others from making, using, exercising, vending, and importing. For example, somebody have invented refrigerator in first instance. Then he will go to patent office, and patent office see the specification, and he will give the exclusive right to stop others from making. That means nobody else can make that refrigerator without permission of that man. That is the right to exclude others from using your invention. Intellectual property right is to exclude others from using your invention. Owner has a qualified right to use the invention. There are some famous inventions and with the inventors, like phonograph was invented by Thomas Hillman Edison, telephone was invented by Graham Bell, aeroplane by Wright brothers, and like that rabies vaccines was invented by Louis Pasteur, and penicillin was invented by Alexander Fleming. Here you can see the picture of a man named George Alfred Depenny. He was a civil engineer in Kolkata. He was the first holder of patent in India. Like he petitioned the government of India for grant of exclusive privilege for his invention. The invention was an efficient pankha cooling machine. Here you can see it in diagram. So he was first patent holder in the India. Here is another famous invention we see in our daily life. This is LED systems. This also shows how I want to told you that this price of these LED systems is in lakhs. So this is simple device, but you can see how patent can be used to commercialize the invention. These are some other famous Indian inventions like this nano card. Here you can see hepatitis vaccine, this Jaipur food. One basic thing about all the Indian inventions is that uh, uh, the aspect is that they tends to make the invention more cost effective. You can see this card, this hepatitis vaccine, and this Jaipur food. All the inventions are cost effective. These are some other examples of patents. So here you can see like patent need not to be rocket science. Like this small umbrella, baby umbrella can also be patented. Like this is very small device, but it is being used for baby bathing, and it can also be patented. And these are some other examples of patent. These devices can be patented. This is to show you. So let us see a video and better understand what patents are.
उस दिन की शुरुआत हर दिन की तरह हुई थी। आईपी नानी कराटे की प्रैक्टिस कर रही थी, तभी उनकी घड़ी में घंटी बजती है।
अरे ये तो आविष्कार कुमार का मैसेज है। मुझे तुरंत उसके पास जाना होगा।
और आईपी नानी छोटू को फोन लगाया।
हेलो छोटू, तू अभी आ जा, हमें कहीं पहुंचना है।
हाँ, अभी आए नानी। नानी हम कहाँ जा रहे हैं?
हम जा रहे हैं आविष्कार कुमार की लैब में। वो यूनिवर्सिटी में मेरा फेवरेट स्टूडेंट रह चुका है और अब एक साइंटिस्ट है। मेरी बौद्धिका घड़ी भी उसी की इन्वेंशन है।
वाह! अरे नानी आप आ गए?
तुमने बुलाया तो आना ही पड़ेगा। और ये मेरा नाती है छोटू।
हाँ नानी, मेरा नाम आदित्य है, छोटू नहीं। हाय आदित्य। हाय सर।
आविष्कार, क्या इमरजेंसी है?
मैं आपको नई इन्वेंशन दिखाना चाहता हूँ। गेस करो मैंने क्या बनाया होगा?
हवा में उड़ती कार?
नहीं। मैं बोलूं कोई ऐसी मशीन जिससे हम गायब हो जाए? बिल्कुल भी नहीं।
अब बहुत हो गया। अब बताओ ना, तुमने क्या इन्वेंट किया है?
मैंने बनाई है एक मशीन।
क्या?
जी हाँ, एक टाइम मशीन जिससे हम अतीत और भविष्य में आ जा सकते हैं। आप बताओ, आप कौन से साल में जाना चाहते हो? मुझे नानी का बचपन देखना है।
What?
चलो फिर, चलो फिर।
अरे ये तो मेरे घर के पीछे वाले मैदान में आ गए हम। देखो देखो, वो देखो, वो मैं हूँ क्रिकेट खेलती हुई।
अरे वाह नानी, आप बचपन से ही रॉकिंग हो। हमें वापस जाना होगा, इसमें अभी ज्यादा फ्यूल नहीं है।
ये तो सचमुच बहुत ही ब्रिलियंट इन्वेंशन है। अब तुम सबसे पहले इसे पेटेंट कराना।
पेटेंट कराने में झंझट बहुत है, मेरे पास तो इतना पेशेंस भी नहीं है। अब मैं अपना काम करूंगा या पेटेंट ऑफिस के चक्कर लगाऊंगा? अरे नहीं सर, ये तो बहुत ही सिंपल है। पता है, मैंने एक जलेबी बनाने वाली मशीन का आविष्कार किया। अभी कुछ दिन पहले ही मैंने www.ipindia.nic.in पर जाकर पेटेंट फाइल किया है।
छोटू ठीक कह रहा है। अब सरकार ने सारा प्रोसेस बहुत ही आसान कर दिया है। तुम अपनी एप्लीकेशन ऑनलाइन भी फाइल कर सकते हो, और तो और वीडियो कॉन्फ्रेंसिंग से हियरिंग भी हो जाएगी।
लेकिन जो सालों साल वेट करना पड़ता है, उसका क्या?
अब ये बात बहुत पुरानी हो गई है। आज की तारीख में भारत सरकार का प्रयास है कि कि 18 महीनों में ही पेटेंट ग्रांट हो जाए। उसके बाद कोई टेंशन नहीं, कोई भी तुम्हारे इस आविष्कार को इस्तेमाल नहीं कर सकता। हाँ, अगर तुम चाहो तो एक फीस लेकर किसी को लाइसेंस कर सकते हो अपने आविष्कार को यूज करने के लिए।
ऐसा क्या? तो मैं आज ही अपना पेटेंट फाइल करता हूँ। हाँ, अब देखता हूँ कौन मेरे इन्वेंशंस को चोरी करता है।
भारत सरकार हमेशा आपके हक के लिए आपके साथ है। अपनी बौद्धिक संपदा को सुरक्षित करें और गर्व से आगे बढ़ें।
I hope you understand patents by this video. Let us proceed. So we will see how patent application is filed. Like if you have invented something, so what to do next? If you want to file patent application in India, what to do? So there are various forms: Form 1, Form 2, Form 3, Form 5, Form 18. Like these forms needs to be filled and you have to submit in the patent office. These are fees. You can look at it. These are like if you are a natural person or if you are a small entity or a startup, then there will be fees of like 1,600. Otherwise, it will be 8,000. In the similar manner, Form 18 is for examination of the patent, and it is for 4,000 for a natural person and 20,000 for other than natural person like a company. So basically, if you have you want to get a patent and you are a natural person, then basic fees will be like 5,600, and for a company or other than natural person, that will be 28,000. This was just to get a rough idea. This is the filing procedure. For filing procedure, you can visit this website ipindiaonline.gov.in. There you can get the whole procedure. So our next intellectual property is designs. So let us see what is design. So basically, design deals with ornamental or aesthetic aspects of an article. It is like feature of shape, configuration, pattern, ornament, or composition of lines or colors applied to any article, whether in two-dimensional or three-dimensional, or in both forms, by any industrial process or means, whether manual, mechanical, or chemical, separate or combined, which in the finished article appeal to and are judged solely by the eye. This is the most important thing. Design is aesthetic aspect, so it should be judged solely by the eye. Like here you can see this is a sari. Sari has some specific design, so this can be registered under design. In the similar manner, this fan has also specific design and it can be registered under designs. Like these articles have designs, so it can be registered under designs. So what is the term of design? Term of design means for how much period it will be your right. So your right will be for 10 years and it can be extended further 5 years, so it is extendable to 15 years. So this is shape, configuration, and surface pattern of bottles. Like these are bottles. So these all the bottles are used for carrying liquid. So what is the difference between these bottles? So the shape, configuration, and surface pattern of these bottles make them different. So these all shape, configuration, and surface pattern of bottle will come under design. Here you can see also some other articles have been designed, like this car and this clock. This will also come under design. So we have seen how a design will be registered for an article, and design can be registered also for a set of articles. Like this is a jewelry set. What is set? Set means a number of articles of the same general character, ordinarily sold together, are intended to be used together, all bearing the same design. Like this pair of shoes, sofa set, this tea set, this jewelry set, this all come under design, and this is come under design of set of articles. So when you apply for a design of an article, then you will receive this certificate of registration of design. This is a specimen copy of certificate of registration of design. So we have seen what is design. Now we will see our next intellectual property, that is trademark. So let us look what is trademark. So trademark is any word, name, symbol or device or any combination thereof. Like you have seen some logo of, like in the first slide you have seen the logo of Apple. In the similar manner, in the logo of Pepsi or Coca-Cola, that will come under trademark. It identifies and distinguishes the sources of the goods or services of one creator from those of others. Like when we see bottle of Coca-Cola, so we have some faith in it, like it will be good, or like anything, like you have seen any shoe of Adidas, so you have faith, like you, if you see the symbol of Adidas, then you have faith like it will be good product. So next, that is our next point. What is the function and importance of trademarks? It provides exclusive monopoly over a class of goods or services. It allows the business entity to build public goodwill and brand reputation. Like Adidas has some goodwill and brand reputation by its symbol, by its trademark. It identifies the source, origin of goods or services. It assures customer about quality of goods or services. That's what we will be talking about. What can be subject matter of trademarks? Trademark itself, like this symbol of Nike. Trade names, like Google. Collective marks, like this Columbia symbol. Certification marks, like this Bureau of Indian Standard symbol, BIS. Taglines or slogans, like tagline of Pepsi, Ye Dil Mange More. This can also come under trademark. The similar way, the shapes of, like the shape of this bottle is can also come under trademark. Sound marks, like you have heard about, you must have heard about this noise of open bottle of this Pepsi bottle. So this will also come under trademark. The sound marks will also come under trademarks. You must have seen these two symbols on various products in your daily life. This TM on some product and this R in the circle is many products. So what is the basic difference between this TM and this R? So these first of all, I want to tell you that these both are related to trademark only. If what is the difference between TM and R? Like if you are saying if you are seeing TM on some product, that means the application for trademark had been filed for that brand, but it may be unregistered, it may be pending in the office. But if you are saying R in the circle on any product, that means the trademark is already been registered. So this is the basic difference between TM and R symbol. So this was all about trademarks. Let us see our next intellectual property, that is copyrights. So what is copyright? Copyright allows the owner to choose the ways his or her copyrighted works are made available to the public. Like if somebody has written a poem or written a novel, then it will be up to him only, like how it will be available to public. Like he want to publish his work or he want to do whatever he want to do. It will prevent unauthorized copying reproduction. Like if somebody has written a novel, then if he have taken the copyright on that novel, then it will prevent unauthorized copying reproduction of that novel, that without permission of that person. So what can be subject matter of copyright? That means on which subjects copyright can be obtained. Literary works, I have told you, literary works, like if somebody has written a novel, a poem, or a book, anything, then he can obtain a copyright on that poem or novel. In a similar manner, artistic works, like somebody have painted up some painting, then he can get a copyright on that. In the similar manner, for dramatic works, like some drama company have some dramas, then it can also be copyrighted. Musical works, like some musics or songs, it can also be copyrighted. Sound recording works can also be copyrighted, and like movies can also be copyrighted. So let us see what is the term of protection for these copyrighted items. If somebody have copyrighted literary or dramatic or artistic or musical work, then the term will be life of author plus 60 years. If there is a film or sound recording, then it will be 60 years from the date of publication. If there is some broadcast reproduction rights, like a broadcast of cricket match or something, then it will be 25 years from the year of broadcast. If somebody have performance right, then it will have term of protection 50 years from the year of performance is made. This term means, like you have seen, some old books are cheap in the price in the market. What is the reason? Because the term of protection has been expired. Like if if you are reading some very old book, like 65 or 75-year-old book, then the price of that book will be low because the copyright has been expired and it is available to common public. So it was all about copyright. Our next intellectual property is SICLD, which stands for Semiconductor Integrated Circuits Layout Design. So let us see what is SICLD. So basically, SICLD is made up of two words, SIC and LD. SIC stands for Semiconductor Integrated Circuit. It means a product having transistor and other circuitry elements that are inseparably formed or inside a semiconductor insulating material designed to perform an electronic circuitry functions. You must have seen some ICs on various electronic devices. That is what SIC is. And second term is layout design. Where different integrated circuit has some different design, the different layout of transistors and circuitry elements. So this is the layout design of that IC. So when we will combine SIC and layout design, then it will be SICLD. That means semiconductor integrated circuit layout design. That means a particular integrated circuit have a particular layout design will be come under SICLD and it can be protected. This intellectual property. Indication. So let us see a video about geographical indication and let us get an introduction of geographical indication.
चिल्ली चोर के साथ घमासान के बाद अब आईपी नानी बिजी हो गई अपनी पोती की शादी की तैयारियों में। संगीत वाले दिन जब छोटू उनसे मिला तो वाह नानी, आप तो बिल्कुल छाए हुए हो। आपके सामने तो मधुबाला का भी कॉम्प्लेक्स हो जाए।
ओए, मस्का लगाना बंद कर। ये बता तुझे क्या चाहिए?
नानी, आपने तो मेरा दिल ही तोड़ दिया। क्या एक प्यारा सा लाडला सा बच्चा अपनी नानी को कॉम्प्लीमेंट भी नहीं दे सकता?
अच्छा चल, एक्सेप्ट किया तेरा कॉम्प्लीमेंट। अब बता तुझे क्या चाहिए?
मुझे कुछ नहीं चाहिए, बस आपकी हाथ की वो स्पेशल वाली चाय पीनी है।
बस इतनी सी बात के लिए इतना बड़ा मस्का?
मस्का नहीं नानी, आपा सचमुच बहुत ही रॉकिंग लग रही हो। ये साड़ी आप पर बहुत ही अच्छी लग रही है।
अरे समुदाय का बौद्धिक अधिकार है, वो विरासत जिन्हें प्रोटेक्ट और एनकरेज करने की बहुत आवश्यकता है। मुख्यतः इन टाइप्स में रजिस्टर्ड होती है: नेचुरल गुड्स, मैन्युफैक्चर्ड गुड्स, टेक्सटाइल, हैंडीक्राफ्ट्स, फूडस्टफ। चल अब ना किचन में चलते हैं और गर्मा गर्म चाय बनाते हैं।
हाँ हाँ। किचन की ओर जाते हुए नानी ने छोटू को अपना देश घुमा दिया।
छोटू,
जी नानी।
ये देख, ये पेंटिंग देख, ये एक मधुबनी पेंटिंग है, बिहार की। और ये है हिमाचल की कांगड़ा पेंटिंग। तेरे नानू को देश की कला और संस्कृति से जुड़ी हुई चीजों को इकट्ठा करने का बहुत शौक है।
अच्छा।
ये कठपुतलियां देख रहा है?
हाँ।
ये राजस्थान की है। इसी तरह छत्तीसगढ़ से बस्तर ढोकरा, आंध्र प्रदेश से तिरुपति लड्डू, असम से मूगा सिल्क, नागालैंड से नागा मिर्च और मध्य प्रदेश के बाघ प्रिंट, ये सब रजिस्टर्ड जीआई हैं।
ओके।
ये हमारे देश की कला और संस्कृति का प्रतीक है। हमारे देश में हुनर और कला का इतना भंडार है कि अभी से ही 300 से ज्यादा रजिस्टर्ड जीआई हैं।
वाह नानी।
चल, अब तू चाय बनाने में मेरी मदद कर। एक बर्तन में पानी ले और उबालने के लिए रख।
यस बॉस।
पता है छोटू, तुझे मेरे हाथ की चाय इतनी पसंद क्यों है?
क्यों है नानी?
क्योंकि ये स्पेशल दार्जिलिंग की चाय है। ये देश की सबसे पहली रजिस्टर्ड जीआई है, जो 2004 में रजिस्टर्ड हुई थी।
लेकिन नानी एक बात बताओ, इस जीआई से फायदा क्या होता है?
देखो छोटू, ज्यादातर जीआई गांव के समुदाय के होते हैं। इनसे कारीगरों, बुनकरों, किसानों की आमदनी बढ़ती है। उनको अपनी मेहनत का सही दाम मिलता है और उन वस्तुओं की डिमांड भी बढ़ती है। साथ साथ खरीदने वालों को भी विश्वास हो जाता है कि वो एक जेन्युइन चीज खरीद रहे हैं।
ओह, वैसे नानी मुझे एक आइडिया आया।
अरे वाह छोटू, तेरे को आइडिया?
यस नानी, अगले महीने फॉरेन से मेरे कुछ दोस्त आ रहे हैं। क्यों ना मैं उन्हें हमारे देश के कुछ सुंदर जीआई प्रोडक्ट्स गिफ्ट में दूं?
ये तो बहुत ही अच्छा आइडिया है छोटू। उन्हें ये चीजें जरूर पसंद आएंगी और हमारे देश की कला का नाम भी होगा।
देखा नानी, आपकी संगत में मैं कितना इंटेलिजेंट हो गया हूँ।
हाँ भाई, ये बात तो है।
और इस तरह एक बार फिर आईपी नानी ने आईपीआर का झंडा ऊंचा लहरा दिया।
I hope you got the idea of GI through this video. So basically, geographical indication is an indication that identifies a product that have a specific geographical origin and possesses quality or a reputation that are due to that origin. These are some examples of GIs, like you have seen. Darjeeling tea was the first GI tag of India, and this Makrana marble. These are Bastar Dokra, Babli Veena, and many more. These are some other examples of GI tags like Katlami Sev of Madhya Pradesh, Kanjipuram silk of Tamil Nadu, and this Katputlis of Rajasthan, Bagh prints of Madhya Pradesh, Bengal Patchitra of West Bengal, Cherial paintings of this and this Bidri Bear, Wali paintings, and many others. Apart from that, these Magai pans, these mangoes, pomelo, this Sahil Lichi of Bihar, and this food orange, and many more. Apart from these, there is one GI tag of Jharkhand also. You must have heard about Sorai cover paintings. That is Sorai cover paintings that comes under the category of handicraft. That is the single GI tag of Jharkhand. So this was all about the GI tag. So you notice it or not, IP is involved everywhere in our daily life. Let us see how IP is involved everywhere in our daily life via this video. So IP is everywhere. I hope after this session you will also notice various intellectual properties in your daily life. So let us come to the validity of different intellectual properties. First of all, we will see patents. Patent is valid for 20 years from the grant of that application. There is nothing called global and international patent. This is important thing. Like if you have invented something, then you will need to apply for patent in various countries, various application in various countries. Like there is nothing called global patent. You cannot if you have applied patent in India, then you also need to apply patent in other countries also as well. Then secondly, we have already seen design. Design is the term of design is 10 years plus 5 years, that is 15 years, extendable up to 15 years. For trademarks, it is indefinite, subject to renewal. That means the term will be indefinite, but after every 10 years, it needs to be renewed. For GI tags, it is also indefinite, subject to the renewal in the similar manner of trademark. For copyright, we have already seen for published literary and other artistic works, there are different terms. Like for literary, it is 60 years. It is 60 years plus life of the author plus 60 years, and like that. So who can apply for this intellectual property? Any individual person can apply for all the intellectual properties rights uh, apart from GI. GI is a collective right; it cannot be given to an individual. These are some important points to remember. So if you have some intellectual property, so first protect it, then publish it. These rights are territorial in nature. That means you have to apply in different offices. And registration is done by sovereign authority. Like in our country, it is done by Government of India. The similar way, these rights are limited period for the limited period of times. We have seen like all the rights have some terms. There is no automatic relief. You need to file infringement suit in the courts, in the other redressal mechanism. There is renewal fees to be paid for some IPRs, like for patents. Appointment of patent agent is not compulsory. Applicant can sign the documents and sign himself. Like you can, if you have invented something, you can come to patent office. Or online mode also, you can file a patent application. What are the career opportunities in patent in intellectual property rights? So there are some government jobs like examiner of patents and designs, examiner of trademarks and GI, examiner of copyright, and there are some other career opportunities like patent agent, trademark agent, some research fellows, and other patent litigations and other opportunities in private sectors. These are the contact details for further training. If you have some questions and you want to get address those questions, you can contact this email rgnipm.iq@nic.in, and we have website. For further information, you can visit this website ipindia.gov.in. This is other contact address. This is the Training Institute of Intellectual Property Office, like the name of the training institute is Rajiv Gandhi National Institute of Intellectual Property Management, RGNIIPM. It is situated in Nagpur, and you can contact there. If you have some queries, you can ask me in message, in chat box.
Hi, sir.
If any students have any question, they can ask.
If anybody has some questions, some queries about intellectual property, right, he or she can ask in chat box. I will try to answer that question.
Okay, I think there is no question from student side. Actually, this event, most likely same event has been organized by our institute as with NIPM previously. So they have
Okay.
doubts. That's why today they are not
Okay.
asking. So
Okay.
I'm okay. If no question from the student side, then I'm very much thankful to the speaker Shubham ji, and
Okay, sir.
please convey my regards to Shukorna madam and Shobha madam for
Okay.
organizing this event such a short time duration in with my request,
Okay.
and hope we will organize this type of event in near future.
Okay, sir.
Thank you, sir. Shubham ji, thank you.
Okay.
Thank you for
Thank you very
your
much.
time.
Thank you all.
Thank you,
Sir.
thank you.
Okay. Okay.
Thank you, sir.